I have the opinion and the judgment of the court in Richard Swann against Tom Adams, Secretary of State of Florida. In March 1966, the state of Florida reapportioned its state legislature. The new plan calls for 48 senators and 117 representatives. Senate districts range in size from 87,000 to 114,000, or from 15% over the average to 10% under the average, with a ratio of 1.3 to 1 between the largest and the smallest district. The deviation from average is over 15% in one district, 14% in 5 others, and more than 10% in still 6 others. The variations among House districts are somewhat more severe. The district court, without articulating any reasons for the variations of this magnitude, approved the plan. We reverse, while Reynolds and Sims and other cases in the reapportionment area have recognized that legislative districts need not be mathematically equal in population and that minor variations are acceptable. None of these cases has approved variations of the magnitude involved in this case, at least without acceptable justification. Here, neither the state nor the district court made any serious effort to explain or justify the particular deviations which this reapportionment plan presents. We therefore reverse without reaching any of the other objections which the appellants have presented to this plan. Mr. Justice Harlan has asked me to announce that he has filed a dissenting opinion in which Mr. Justice Stewart has joined.
I am authorized to announce the opinion and judgment of the court in number 53, National Labor Relations Board petitioner against C&C Plywood Corporation, a case which we brought here on certiorari to the United States Court of Appeals for the Ninth Circuit. The respondent, employer, the Plywood Corporation, was brought before the National Labor Relations Board to answer a complaint that its inauguration of a premium pay plan during the term of a collective bargaining agreement without prior consultation with the union representing its employees violated the duties imposed by Sections 8A5 and 1 of the National Labor Relations Act. The board issued a cease and desist order rejecting the claim that the respondent's action was authorized by the collective agreement. The Court of Appeals for the Ninth Circuit refused, however, to enforce the board's order. The court reasoned that a provision in the agreement, in the collective bargaining agreement between the union and the employer, which arguably allowed the employer to institute the premium pay plan, absolutely divested the board of jurisdiction to entertain the union's unfair labor practice charge. We granted certiorari to consider what seemed to us a substantial question of federal labor law. For the reasons set out in some detail in the written opinion which has been filed with the clerk, we reverse the judgment and remand the case to the Court of Appeals for enforcement of the board's order. In number 52, I also have for announcement the opinion and judgment of the court. This case is National Labor Relations Board against ACME Industrial Company, a case which is here on writ of certiorari to the United States Court of Appeals for the Seventh Circuit. In the C&C Plywood case, which I've just announced, we dealt with one aspect of an employer's duty to bargain during the term of a collective bargaining agreement. And in this case, another aspect of that problem is involving the obligation to furnish information that allows a union to make an informed decision as to whether or not to process grievances. The board found that the information which the union requested of the employer was necessary in order to enable the union to evaluate intelligently the grievances it had filed. And the board pointed out that the collective bargaining agreement contained no provision by which the union had waived its statutory right to the information it requested. And accordingly, the board upheld a charge of the employer's violation of its duty under Section 8A5 of the Act to bargain in good faith. The Court of Appeals refused to enforce the board's order. It did not question the relevance of the information which the union had requested, nor did it question the board's finding that the union had not waived its right to the information. But the court ruled that the existence in the collective bargaining agreement of a provision for binding arbitration of differences concerning the meaning and application of the agreement foreclosed the board absolutely from exercising its statutory power. For the reasons discussed in the written opinion, we disagree with the Court of Appeals, and accordingly we reverse the judgment and remand the case to the Court of Appeals for the Seventh Circuit for enforcement of the board's order.
I have for announcement number 22, Time INC versus Hill, which is here from the Court of Appeals of New York. This lawsuit is a sequel to publicity given to an experience suffered by James Hill and his family of 5 when they lived in a suburb outside Philadelphia. 3 escaped convicts entered their home and held the family hostage for some 19 hours. The plight of the family during that time became a matter of national news and concern, and thus the family involuntarily became news celebrities. When the family was released by the convicts, Mr. Hill held a press conference. Contrary to the fears of the country, he reported that the family had not been harmed in the slightest, that the convicts had treated them courteously and had neither threatened nor molested any of them. Now, Mr. Hill wanted his family to forget the experience, and he rejected all magazine and television offers to reenact it, and shortly after it occurred, the family moved from Pennsylvania to Connecticut. 3 years later, James Hayes wrote a novel, became a bestseller, called The Desperate Hours. That novel depicted the experience of a family of 5 held hostage by 3 escaped convicts in the family's suburban home. And later Hayes wrote a play with the same theme and also called The Desperate Hours. Now, the family of the novel and the family of the play was not named Hill, but the experience depicted was in sharp contrast to the actual experience suffered by the Hills. The family of the play was subjected to violence. The father and son are beaten, and the teenage daughter is subjected to a verbal sexual assault. The play opened in Philadelphia, and when members of Life magazine's staff learned that the story theme was similar to the Hill family's experience, Life decided to review the play in an unusual presentation. Life arranged to photograph the cast of the play, reenacting scenes from it in the house which had been the Hill family home in the Philadelphia suburb. The photographs taken at the home were then used to illustrate Life's review of the play. Now, that review falsely stated that the play, in fact, reenacted the Hill family's experience. And thereupon, Mr. Hill brought this lawsuit for damages under a New York statute which provides that any person may recover damages whose name, portrait, or picture is used within New York for advertising purposes or for the purposes of trade without having first obtained the written consent of such person. And Life had made no effort whatever to obtain the Hill family's consent to the use of their name in the article about the play. Well, a jury awarded damages to the Hills in this action, in which the New York courts, starting with the trial court through the appellate division and up to the Court of Appeals, rejected Life's defense that the article was a subject of legitimate news interest and that in such circumstances the application of the statute to award damages denied constitutional protections for speech and press. So the constitutional question we have to decide is the narrow one whether a newspaper or magazine may be subjected to damages for a false report of a newsworthy event. The New York courts have made crystal clear that a truthful report of newsworthy people or events is not actionable under the New York statute. Those courts have held that a newsworthy person has a right of action under the statute only when his name, picture, or portrait is the subject of a fictitious report or article. Material and substantial falsification is the test. The establishment of minor errors in an otherwise accurate report does not prove fictionalization under the New York cases. However, it's not clear in those cases whether there is liability in the absence of proof that the newspaper or magazine knew that the report was false or published it with reckless disregard of its truth. Now, for the reasons detailed at greater length in our opinion, we hold that the constitutional protections for speech and press preclude the application of the New York statute to newsworthy persons, I emphasize, in the absence of proof that the newspaper or magazine published the report with knowledge of its falsity or in reckless disregard of the truth. The guarantees for speech and press are not the preserve of political expression or comment upon public affairs, essential as those are to healthy government. One need only pick up any newspaper or magazine to comprehend the vast range of published matter which exposes persons to public view, both private citizens and public officials. Exposure of the self to others in varying degrees is a concomitant of life in a civilized community. The risk of this exposure is an essential incident of life in a society which places a primary value on freedom of speech and of press. Freedom of discussion, if it would fulfill its historic function in this nation, must embrace all issues about which information is needed or appropriate to enable the members of society to cope with the exigencies of their period. And we have no doubt that the subject of the Life article, the opening of a new play linked to an actual incident, is a matter of public interest. Erroneous statement is no less inevitable in such case than in the case of comment upon public affairs, and in both, if innocent or merely negligent, it must be protected if the freedoms of expression are to have the breathing space that they need to survive. We create a grave risk of serious impairment of the indispensable service of a free press and a free society if we saddle the press with the impossible burden of verifying to a certainty the facts associated in news articles with a person's name, picture, or portrait, particularly as related to non-defamatory matter, which this was. Even negligence would be a most elusive standard, especially when the content of the speech itself affords no warning of prospective harm to another through falsity. A negligence test would place on the press the intolerable burden of guessing how a jury might assess the reasonableness of steps taken by it to verify the accuracy of every reference to a name, picture, or portrait. In this context, sanctions against either innocent or negligent misstatement would present a grave hazard of discouraging the press from exercising the constitutional guarantee. We must all remember that those guarantees are not for the benefit of the press so much as for the benefit of all of us. A broadly defined freedom of the press assures the maintenance of our political system and an open society. Fear of large verdicts and damage suits for innocent or mere negligent misstatement, even fear of the expense involved in their defense, must inevitably cause publishers to steer wider of the unlawful zone. But the constitutional guarantees can tolerate sanctions against calculated falsehood. without significant impairment of their essential function. We held a term or two ago in New York Times versus Sullivan that calculated falsehood enjoyed no immunity in the case of the alleged defamation of a public official's official conduct. Similarly, calculated falsehood should enjoy no immunity in the situation presented in this case. The use of calculated falsehood puts a different cast on the constitutional question. Although honest utterance, even if inaccurate, may further the fruitful exercise of the right of free speech, it does not follow that the lie, knowingly and deliberately published, should enjoy like immunity. For the use of the known lie as a tool is at once at odds with premises of democratic government and with the orderly manner in which economic, social, or political change is to be effected. Now, we find applicable here the standard of knowing or reckless falsehood, not through blind application of our decision in New York Times v. Sullivan, which related solely to libel actions by public officials, but only upon consideration of the factors which arise in the particular context of the application of the New York statute in cases involving private individuals. Now, this is neither a libel action by a private individual nor a statutory action by a public official. Therefore, although the First Amendment principles announced in the New York Times v. Sullivan guide our conclusion here, we reach that conclusion only by applying these principles in this discrete context. Now, as this case went to the jury, the Hills were regarded to be newsworthy persons, substantially without a right to privacy insofar as their hostage experience was involved, but to be entitled to a recovery insofar as that experience was fictionalized and exploited for life's commercial benefit. And it's clear that the proofs reasonably would support either a jury finding of innocence or mere negligent misstatement by Life, or a finding that Life portrayed the play as a reenactment of the Hill family's experience, reckless of the truth, or with actual knowledge that the portrayal was false. The difficulty here is that the instructions to the jury did not confine the jury to a verdict of liability based on a finding that the statements in the Life article were made with knowledge of their falsity or in reckless disregard of the truth. And our opinion analyzes the instructions in detail to demonstrate the error in the instructions in that respect. Now, Life argues that the statute should be declared unconstitutional on its face if construed by the New York courts to impose liability without proof of knowing or reckless falsehood. We don't think that such a declaration would be warranted. The New York Court of Appeals has been assiduous to construe this statute to avoid invasion of the constitutional protections for speech and press. And we therefore confidently expect that the New York courts will apply the statute consistently with the constitutional command. Any possible difference with us as to the thrust of the constitutional command is narrowly limited in this case to the failure of the trial judge, as I said, to instruct the jury that a verdict of liability could be predicated only on a finding of knowing or reckless falsity in the publication of the Life article. The judgment of the Court of Appeals is therefore set aside, and the case is remanded for further proceedings not inconsistent with our opinion. Justices Black and Douglas asked me to announce that they have joined the court's opinion, but have also filed separate concurring opinions. They expressed the view that to allow liability in these cases, even though limited to cases of knowing and reckless falsity, is to abridge speech, but have joined the court's opinion in order to make possible an adjudication that controls this litigation. Mr. Justice Harlan has asked me to announce that he concurs in the judgment of reversal, but would predicate liability on a negligence standard rather than on a standard of knowing or reckless falsehood. Mr. Justice Fortas has asked me to announce that he has filed a dissent in which the Chief Justice and Mr. Justice Clark have joined.
The other orders of the court have been certified by the Chief Justice and filed with the clerk and will not be announced orally.